Hi everyone, welcome to another week of Crystalcast. Today we're going to talk about Federal Circuit Court and jurisdictional errors. We get quite a number of cases and inquiries about, well, can you take a matter to court? So what I wanted to do today is discuss how do you take a matter to court, and let's start off with what's a jurisdictional error, Matthias?
Thanks, Ross. Jurisdictional error, also known as procedural error, is when the department or the tribunal they make a mistake in relation to the procedure to be followed. For example, when you made an application for a certain stream of a visa and they review it as if it was another one. Usually, your jurisdictional errors are not very common, but they often happen. So.
That's a good sort of line that you said there, that they're not common but they do happen. I think there's that perception, let's say for example, if the matter gets affirmed at the ART, there are appeal rights, but you have to identify jurisdictional error.
Yeah, it's not every decision from the AAT or ART that can go to court. It's basically limited to what the tribunal can do and what they cannot do.
All right, I'm going to ask you a bit of a difficult question. What if I'm not happy with the decision of the ART? Can I take the matter to court?
I'm afraid not, Ross. The court should not be used just to buy time or extend your stay in Australia. Neither the tribunal, but the court has more serious consequences because you can be ordered to pay costs to the other part and to court. Basically, the court is expensive in comparing to administrative procedures.
Yeah, that's a good point, and I suppose one of the key takeaways is that when you go to the ART, it's a merits review. So say for example, you didn't, well, let's use a partner visa example. The Home Affairs did not agree that your relationship was genuine. So in theory, you can take the case to the ART if you have more evidence to present, and that would be merits review because the ART would look at the entire case. Whereas a jurisdictional error, it's a very clear sort of procedural error. So for example, let's say if there was a complication with a partner visa, such as Regulation 1.20J, so serial sponsors, and the ART did not assess that properly. So they've applied the wrong regulation, or they didn't apply a particular regulation, then that's a jurisdictional error. So I suppose an example that I wanted to draw on is that sometimes people, out of desperation, do come and say, we want to apply to the Federal Circuit Court, or even maybe make an example and say, we don't agree with a particular decision. Unfortunately, or maybe fortunately, courts are not there to prove a point. They are there to look at to see whether there's a jurisdictional error. And one of the things that you've mentioned as well is that as solicitors, we do sign off a statutory declaration to say that there are merits to a case. So if you bring something that's futile or vexatious, there could also be ramifications for the practicing lawyer as well. So many lawyers will actually reject the case and say we can't take it to court. And we had examples, say, where students finish their course and they still have a matter at the Federal Circuit Court and they want to go and argue the case. But the problem with that is that, well, there is no case to argue. So you may not agree with that decision that was made by the ART, but the courts are not the avenue. So on that note, when should you not apply to the Federal Circuit Court?
You actually gave a really good example, Rose. When you don't agree with the decision that was based on merits and there was no jurisdictional error, you definitely should not apply to court. Because if you go with what we call a vexatious application, you will be ordered to pay cost, and you also will have the church on you because of that.
It's not a pleasant experience.
Not at all, not at all. Rose, I have a question for you. What the court can do and what they cannot do when you apply for the Federal Circuit Court?
That's a good question. Look, the court can't grant the visa. That's the bottom line. So let's say if there is a jurisdictional error, they can't review the decision of the primary decision maker, meaning they can't see whether the Department of Home Affairs made an error. but they could review to see whether the tribunal has made an error and either quash that decision or send it back for the review. So really what they could do is they can impose what's called orders for the case to go in a particular way. And unlike the tribunal, those orders are legally binding, meaning that the tribunal can't look at it and say, well, we either agree or disagree with it. They have to look at the case. It doesn't mean you'll get a favorable decision, but what's important to understand is that if the case gets sent back to the ART must look at it, and then they'll arrive at their own conclusion.
Yeah, that's good. Just at this point, the ART now, they can only make 3 types of decision. One is to affirm the decision of the department or the primary reviewer, to send it back to the primary reviewer for another analysis of your case. And the third one is to substitute the decision with a new decision after they have an independent look at the case. The Federal Circuit Court, as Ross mentioned before, they can quash the decision, but they need to send back the case to the ART or the second reviewer, the second decision maker. So one of the questions that we've received is, if the department has made the mistake, can the Federal Circuit Court send the case directly to the primary decision maker?
Unfortunately, they wouldn't be able to do that. So we actually had a case where the error was made by the Department of Home Affairs, but it needs to go through, it needs to go back to the ART or the AAT, depending on sort of what the which legislation applies at the time. And there are quite a number of precedents in relation to that. So I think because of all these, specific requirements, it is important that you do seek legal advice. With the ART, it's fine to be self-represented. My personal belief is that, everyone should be able to access merits review. With courts, it's a little bit different because there's a lot of procedural work, meaning that if you don't know what the procedure is, if you don't know how to serve documents, if you don't serve the documents within time, the case could be thrown out, and that's probably the best case scenario, but then you'll be awarded costs as well. So running a case and not knowing what you're doing is probably going to be quite a severe detriment in the long term.
So Ross, we've been talking about being ordered to pay costs to the other party and to the court. So what are these costs, and how much should the applicant pay if they lose the case in the Federal Circuit Court?
Well, the costs are generally suggested by the minister. So, for example, if the matter is brought to court, the minister will, or the minister's representative, I should say, will make recommendations, and that could be anywhere between $2,000 and $6,000 depending on the case. It could be more. So that's sort of a ballpark figure. If you've got, say, a 186 nomination visa, you've got to double that cost because it's 2 applications. Now, if you can't pay that cost, then that's a debt to the Commonwealth. And what could potentially happen is that, let's say, if you leave Australia, you don't pay the cost, and then you come back on a different visa, you could actually be stopped at the border, and your visa could be subject, not necessarily to a cancellation, but to further scrutiny. And we did have an inquiry not too long ago where someone was stopped at the border because there was an unpaid court bill. So it is quite serious, and I think there needs to be a well-informed decision. We normally don't encourage clients to go to Federal Circuit Court unless there's a clear jurisdictional error that's been made. So again, just to recap, the law hasn't been applied correctly, and it's very evident from the decision record. So we discussed incorrect stream. The tribunal has gone outside the regulations, so they've looked at something that's not relevant to the case, or potentially the facts haven't been considered properly. So we had situations where the client's gender was incorrect, their nationality was incorrect, and that is relevant, say for example for an assessment of a protection visa application, because, well, if you're looking at the wrong jurisdiction when making protection claims, then that's clearly a jurisdictional error. But if, going back to that partner visa example, the Home Affairs thought your relationship is not genuine, the ART agreed with that decision, and they followed the same procedure, there is no jurisdictional error. So your case would essentially be vexatious and you would be awarded costs, but there could be further ramifications. And the question would be, why is that case before the Federal Circuit Court to begin with? So there needs to be a very clear consideration about that.
So Ross, I have another question for you. Let's say that we have a clear jurisdictional error. We appealed to the Federal Circuit Court, but they didn't see that error. Is there anything else that we can do after that point?
Yeah, definitely. Look, there's always an appeal. You can go high. You can go all the way to the High Court if you wanted to. This is admin law, so admin law means federal, and the High Court is the highest that you can appeal to. But this is where there needs to be an informed decision as to how much further you want to push it. So at that stage, I definitely would encourage getting a specialized barrister to be able to represent you, and also just be prepared for quite substantive costs, because if you're going to be running a matter before, say, the full bench at the Federal Circuit Court, or if you are going to take the matter to the High Court, it is very time consuming, and also it is a very expensive process. So sometimes this is where legal system can be a little bit unfair. Sometimes there might be an error, but it's worthwhile considering, well, are there any maybe cheaper alternatives? And that could be going offshore and lodging another visa. That could potentially be a solution to the problem.